Hi everyone, welcome to the Bar Exam Academy's preparation course for the evidence component of the Victorian Bar Entrance Exam. My name is Dr. Kai Luck, and I'll be helping to guide you through the material. So this year, as you may have already seen, Vic Bar has decided to establish two evidence streams for the exam. There's both a civil stream and a criminal stream. The core study material is substantially the same, but you do still need to select one stream to go into, and there are separate exams for both streams. The practical distinction, there are some bespoke provisions for each stream, which I'll go into in a little more detail shortly. But as I said, potentially around 75–80% of the material will still be the same. In approaching your preparation and study for the evidence component of the bar exam, please read carefully through the 2025 reading guide that's been issued by Vic Bar. You'll see that that sets out all of the key legislative provisions from the Evidence Act, some selected cases, and some textbook reading. What we suggest is to tackle each key area one at a time. Don't get overwhelmed by the volume of information by trying to do it all at once. That's one easy way to talk yourself out of it and to feel like you're not going to be prepared, when the reality is if you approach simply one topic at a time, you'll definitely get there. And on that front, just be diligent in ensuring that you do get through each topic. Don't leave it all to the last minute, because as you may remember from university days, evidence in particular is a pretty complex area. And if you aren't across the detail and don't have, importantly, a clear exam answer plan, it's going to make it pretty difficult to pass. So one of the most important preparation strategies, I believe, for evidence is to put in place really just a flow chart of how all of the provisions tie together and have a step-by-step outline of the key issues that you want to be considering in any exam question. It's very easy to get caught in a vacuum with evidence and to drill down too much on niche issues. For example, the hearsay rule. You might know about the intricacies of that rule, but then you might forget in an exam answer to talk about relevance, which is an overarching test that you would need to consider in possibly determining whether evidence is admissible even before you get to the hearsay stage. So you don't want to be missing those broader key issues by drilling down too much. Keep in mind the big picture. On that front, there's a very useful evidence answer structure that's been uploaded on the Bar Exam Academy study portal. And I suggest you review that and get familiar with it from the get-go. And you can use that as your own answer and study template, build it out as you go along through the course material, put in your own notes, some little things that will jog your memory in answering a question, and make that your key study tool that you can keep at the front of all your notes and keep referring to so that you get it very clear in your mind. I need to approach 1, 2, 3, 4, and 5 things in any question that I'm asked. The traditional IRAC method is also a general best practice way to structure your exam answers. I would suggest not being too formulaic about it. Certainly don't be saying things like, here is the issue, here is the rule, the application, and conclusion, and don't put headings or anything like that. It's just a general way to help you in your own brain structure your answer to ensure that it's cohesive and readable for the examiners. So you identify the issue. What are then the relevant provisions from the Evidence Act? How do I apply those to the facts? And then, most importantly, come to a clear conclusion. Don't sit on the fence. Often with evidence, there are competing views. That's why we see so many appeals to higher courts on evidentiary issues, aside from the substance of the matter. So judges reach different views about the evidence all the time. Don't be afraid to come to an answer. The key texts in the reading guide, which are issued by the Judicial College of Victoria, are extremely helpful. So please befriend those as your study guides. It's useful, I find, to have the texts open along with the legislation from the Evidence Act as you work through each topic, as well as our supporting materials from the Bar Exam Academy. The recommended text is by Stephen Odgers. It's not prescribed as such, but it really is one of the leading texts in the market. I resort to it frequently in practice, and I think it would come in handy for you when you're actually at the bar as well. So worth the investment, or at least having access to a copy during the course. For the substantive material, for some of you, it may have been a while since you've had to recall key evidence principles. If you're not in a litigation-focused role currently, or if you're not working in criminal law, or on the other hand, if you haven't been in active practice for some time or at all yet, it could have been quite a while since you've looked at evidence. But while it's often viewed as a hard body of law, I think what I certainly found beneficial when I did the bar exam many years ago was that coming back to it for a second time years after university can actually be quite refreshing, and you can have experience and perspective that you didn't have at university the first time around. So I think approach it from that angle as well. Don't get overwhelmed, just come back feeling more empowered about it this time. So going back to the material, you'll see that the Vic Bar reading guide includes 17 or 18 core topics, and most of those are shared across the civil and criminal streams, as I said, but some are unique to each. So for the civil stream, there's bespoke focus on the rule in Jones and Dunkel, which relates to inferences that can be drawn when a party fails to provide evidence. The hearsay exceptions under Section 63, 64, and 68 of the Evidence Act, civil standard of proof, unreliable evidence, and waiver of rules of evidence in Section 190. Then in the criminal stream, we've got a unique focus on special compellability of spouses in criminal matters, as well as evidence given by police, criminal hearsay exceptions. Admissions is a really key topic for criminal matters. Evidence of silence and its impact, tendency and coincidence evidence are really another meaty topic that you'll need to get your head around if you're in the criminal stream. Cross-examination on credibility, character, identification evidence, and discretionary exclusion in criminal matters. Some of the topics that do tend to trip students up the most are hearsay and admissibility, and also that tendency and coincidence evidence that I referred to just now. So do pay close attention to those topics, as they'll inevitably come up in some form in the exam. Be aware too, when you see the reading guide, there are selected cases for each stream. So print those out and make sure you carefully read through them, identify the key issues in the cases, because that's going to be an indication of what the examiners can draw on to question you in the exam. They're included for a reason. So for the civil evidence stream, the selected case is Nathan and Macquarie Leasing, which concentrates on the business records exception to the hearsay rule, Section 69 of the Evidence Act. A really important provision. Most commonly, you'll find when you're at the bar that that's what you'll rely on in civil matters to get substantial volumes of information admitted without contravening the hearsay rule. And importantly, that case affirms that even if you do get the evidence in, though, you've still got to satisfy the opinion rule if you have any particular items of opinion that are in that volume of evidence that you may put before the court. Case also provides useful explanation of other aspects of the opinion rule, the overarching test for relevance. So again, even before you get to hearsay exceptions, always consider, is what I'm looking at actually relevant? Is it going to influence the court's or the jury's assessment of the key facts in issue? If not, then it won't be admissible. And finally, that case looks at the discretionary exclusion of evidence, which is unfairly prejudicial, misleading, or confusing. That's Section 136 of the Evidence Act, and that applies to both civil and criminal matters. I really do suggest that you get across that very early as well, because discretionary exclusion is a really key thing that you're going to be dealing with, both in the exam, but also at the bar. And it has really profound implications. You might otherwise have something that's admitted, but then you get to this final hurdle, the court can still exclude it if it's going to be prone to misleading, confusing a jury, or if it's unfairly prejudicial to another party. and that can outweigh its probative value that it otherwise may have. Then for the criminal evidence stream, the selected case is Moore and the King, and that case looks at another discretionary exclusion under Section 137 of the Evidence Act. So that's circumstances where the evidence, it might have probative value, but you have to do really a weighing exercise. Is that going to be outweighed in a given case by danger or unfair prejudice that the evidence could cause to the defendant? And you'll find that that comes up really frequently, particularly when the prosecution is trying to rely on tendency or coincidence evidence or character evidence. Yes, sure, it might be relevant, but is it going to be unfairly prejudicial to the defendant in circumstances where, for example, the individual who might put forward that evidence is not available for cross-examination? So that really comes up in Moore and the King, and you'll be able to get a good understanding of that from that case. So that's really it for now. Good luck with your study, and remember that we are here to help at the Bar Exam Academy to guide you through your preparation and ensure you're comfortable and ready to sit the exam, and importantly, to hopefully go on and have a very successful career at the bar. Thank you very much.